Everyone. I want to welcome you to the first week in class. You'll have to get over my bronchitis just a little bit. I apologize for it. But I'm going to try to work my way through our first lecture series here that we're going to be on a journey with together. And I want to talk to you first just on the premise of what we're going to be doing in a course for a paper. And I kind of framed out a paper and wrote one for you real quick and thought I would walk you through my mindset and process on how we're going to deal with these legal and ethical communication issues in cyber law today. It's kind of more or less an understanding of where the law came from, where it's framed, how the platform started, and how it's continuing today. Because if we think about these lessons, we're always working to communicate. In the cyber domain, internet domain, whether we're coding, whether we're creating an interface and design, it's all about communications and fostering relationships and making sure businesses communicate effectively. We can look back into the early 40s when example of Pearl Harbor attack happened with the Shannon and Weaver model that came out. Essentially, the scholars came up with the idea of there was a transmission from a sender through a channel, which you got the message, we received it from the recipient or receiver where it was decoded. Inside this was called a transmission loop, and if there's no problems, it went straight through and the transmission loop came back with a positive feedback. But if inside there was a noise. We're doing the same thing with the internet today, through nodes, computers, data banks, whether we send a message to the data mart and pull back binary code to get the message for what the URL code says at Walmart to find out what the cost is. These are all simplistic, same models of communications. They're a measure of making sure the ends meets our needs. We're always looking forward to making sure our goals and tasks are completed for every single user. The difference today is a lot of people forget because of the digital native culture. These are the students, or sometimes a lot of you, that grew up with telephones with no cords on them. In my day, we had to talk to our first boyfriend and girlfriend. We'd have a 16-foot cord and we'd curl it around our fingers, around our arms, and we'd talk and walk, and our parents would yell at us. A lot of you grew up in a society to where you never had a phone with a cord, or you never knew the fact that there wasn't phones that weren't connected to your car batteries when you had to have a remote transmission or go to a public telephone booth and actually have the correct amount of change to make a call. These are all functional attributes in interfaces and designs. Today our world is interesting because as things grow with technology, it opens up new doorways to get sued, to libel somebody, to have a defamation of character brought upon yourself, or a new presiding law. All of these laws still grow out from the original ones. We can date back to the kings. And we can bring all this in, and I want you to learn how to tie it together to make a very tight-knit statement about something today and possibly how it will change for future implications for your employers, yourself, your organizations, or the world. Or maybe you're working for the federal government, like a lot of my friends in the NSA and a few other branches of the DoD, and the laws that they fight today, trying to gain access. And we see this a lot today with Apple and the smartphones, with the continued war on infiltration and the government's need to find information and what type is there of balance. But they all come back to the same idea: the transmission, the receiver, the transmission loop, and the noise. And the noise is what's always the interesting part, and that's where a lot of times we find our ethical debates and our legal debates that we'll be talking about. And you'll be using LexisNexis. You can gain access to this off of the library server for free, and search background for cases. And you can search all the journals and peer-reviewed journals. We will not use Wikipedia or anything like that. It all must be peer-reviewed or from a law journal for any of your writings, or books in published print from scholars. But we'll use this to frame out our papers. So the first thing we're going to do is we're going to start learning about understanding communication legal groundwork. And one of the biggest platforms is always, if you think about it, back to the day, whether it was reeds in Egypt or a newspaper, these are all platforms. They're a way we transmitted messages. They're a way we brought the news, the information, the data, which we turned into information from patterns and themes to make meanings into what we learn today. The internet and cyber idea is no different. It's a platform, it's a transmission loop. It is a way to funnel data from one point to another, to crunch that data to bring into patterns and themes an understanding and a knowledge for us. What is interesting is how the world changes because of this, because of the abilities to steal, to pilfer, to break into through different measures than the traditional hammer or nail, or whatever they do to jimmy a door to get inside a business. Today, a lot of businesses are robbed that we see, like Home Depot, to where tons of people's information was stolen and utilized later for theft, all because of binary code and a back door. Apple's facing these fears today with the new programs it's instituted, but laws going the whole way back into the 1800s are seeking out a way for the government and a behalf for them to actually call into action a knowledgeable base for them to have to turn over a way to get into personal phones, into personal information. A writ of wills is one of the ways that the government is currently using this, and we'll talk more about that. But it's also a way that they can frame out an idea, and you have to legally find a way to base this. What is our rights of privacy versus the public's greater good? Maybe you find something on that and how the internet is changing the way our personal freedoms are changing, or the way that is protecting us. So this is something you're going to look at. So I framed out a paper I wrote and I'm going to present to you guys. And I want you guys to have this completed. It should be a really tight-knit, max 10, 15 page paper at the end that is publishable. And we'll work together on this, frame them out together, and I can help a lot of you get them published and co-author with you if you guys get to that point. But you'll have to be able to reach a deadline for the IASIS conference, which does cyber scholarly platforms, which you'll be racing to meet your deadline. So you will have to be working diligently to get this done. And in the end, you'll have a published piece, which will be fantastic. And if so, you get an A. That's one of the good conditions. So framing out a paper how I did today, I thought would be the best thing for you to take down a little bit of the nerves, because I know this is your first graduate work on this scale. I want you to think about the process that you're learning in your research courses. It's the same. We're going to have an introduction. What are we trying to say? An abstract. We're going to have the introduction. We're going to have the literature review where we find a background, but this time it's kind of in laws and the way it's framed out the thing we want to talk about. Then we'll bring into the discussion our point of view. Maybe it is the breach in availability of the government to get into your databases, access your organization's records, go into your healthcare information, or how North Korea is attacking 3 to 4 times a day on a daily basis the Native American healthcare database. Why would they want to do that? Interesting. Well, it's run through the naval industry, and a good friend of mine is actually in charge of it. He's a doctorate who just graduated, soon to be Admiral Mark Reeves, Admiral Dr. Mark Reeves. And his biggest job is stopping Korea and China on a daily basis from gaining access to the Native American health care, because it's run through the Navy. And if they get access through the naval platform to any of that, they can go anywhere in our government. Our banking industry is still wrote off a binary code. This is all the same platform. They're just looking for an entrance. The smarter the criminals, the smarter the laws have to be. So let's frame out something from a perspective of communications law and how it's changed over the years, but hasn't changed. I looked at a case, first of the historical newspaper platform, and then one of the quotes I loved was, "Heed the rising voices." And you'll remember this is back in the early civil rights days, when the case of New York Times versus Sullivan came out. Very interesting case. It still stands today in presiding law everywhere. The New York Times published a full-page advertisement from a civil rights group that was on a campus wanting to admonish the actions and said words of L.B. Montgomery, who was an Alabama commissioner. They called him a Southern violator. They framed him out in a defamed way, made him look very poor, and through means of exposing this, the courts decided to fine New York Times $500,000 in damages and $2.5 million excessive damages. And they did this because of a few reasons. And they found there was what's called actual malice. And actual malice is a knowing and understood value, that you knowingly knew there was wrong being done, a falsehood, and you had intent to allow a person to be harmed in character, action, economic value, or standpoint. And this knowing of the falsehood and the clarity of knowing is what allows the presiding laws to say you have actually caused somebody defamation of character. In this, we actually use the terms of actual malice, or liable pro se and liable pro quo. These can all be done the same way. A printed form, which we would write a quote that Dr. Spangler is stupid, he never graduated from school, and you publish it, let's say today, on the student newspaper, or maybe your blog space. Well, that's publishing. That means I can come back, I can see a date when it's published, a time, I can get to your IP address, and I know that's a falsehood. I graduated school, I'm not stupid, I got a job, I'm here with you guys. I'm really a nice person. Well, I feel terrible. I have to go get help. I talk to a therapist, I go to a doctor, I get sick over it. Well, all this is called defaming me and causing me falsehoods, and I'm actually losing my will, the motive to work, to want to come to work, to read, to want to lecture to you. These are all reasons to where the courts will say, liable pro se, you directly knew a falsehood, wrote this falsehood, transmitted it in a transmission loop for others to see. It doesn't matter if one person or no person sees it at this point. It's published. It's out there in cyberspace, and who knows who could have recorded it, seen it, captured it. And it has caused me feelings of ill regard, falsehood, defame. The other option is liable pro quo. We'll talk a little more next week about this in definition of laws, about how you can infer, like they did in the case of New York Times versus Sullivan. They never actually wrote the Commissioner Montgomery's name, but they gave enough facts about where he was from, that he was a commissioner, that he was round, that he was overweight, and various details that people could understand who the man was. The law says there's two different types of people, officially, but there's really a third. The first person we all know is the public official, the president. Maybe our president of the university could be that person. Then there's the private person. There's you and I. We go to maybe the sewer board meeting. We go to classes, and we don't look for ridicule. And then there's a third person, is the vortex public official. And that person is the one who stands up at a public meeting and says, this is wrong. You can't call Dr. Spangler stupid. He's got a degree. He's very smart. Go look at his bookshelves. He has hundreds of books. He reads all the time. If you ever want to find him, he's either in the library or in his office. Or maybe at noon at gym. And he's usually reading a book on the treadmill. These are people that stand up for others. And when you do that, you lose the identity of yourself because you become a public person for someone else. The case I'm going to look at and explain to you is a person that does that. Near and dear to my heart is the Americans with Disability Act and people who go out of their way to help others. So I always try to find ways to help them. The paper that I'm going to be presenting to you guys talks about this. A wonderful woman I met years and years ago as a journalist who fought for handicap rights and accessibilities for individuals who are hearing impaired, sight impaired, or have physical difficulties. Marilyn Phillips. Digressing a little bit, but what's the difference? There's really no difference between the internet, what we're seeing today, and how I'm communicating to you, than if I wrote you a letter and emailed it to you. Or if I wrote you a letter and took it to the post office and mailed it to you. Time is the only difference. It's still data, it's still information, it still has value, it still has economic value. The difference in this, and I look at the case of Phillips versus Burrowvent.com for my papers construction for the course for you guys. And the first thing I had to say was, what is this about? Well, I had to understand what the law is of communications and how New York Times versus Sullivan came in and how these laws actually set up this piece today. So I framed it in past laws, which is the easiest way to do is building a case through the literature and finding a hole or finding a way to support your idea and your concept. Here we're not really proving anything. In the end, we'll be making suggestions for furthering our research or understandings or waiting to see the next merits. But we're looking to frame out a way to say, here's what's happening. Describe how the past influences are influencing the future. So, describe how the cyber domain is actually the same but different, but opening new ways and new avenues for lawsuits and legal actions or court orders. So let's frame out this case. Well, Marilyn Phillips is a wonderful professor from Maryland, and she has been handicapped for years and works to go to historical sites and community sites where everyone should have free access to make sure everybody has access. Her in particular problems are that she is in a wheelchair and she has functionality problems, so she can't get upstairs. And one of the places that she goes to is public education, universities, make sure all the walkways are safe. Others are places that I love, like Gettysburg. If you've never been there in Pennsylvania, it's a marked place for the Civil War actions. Very historical value. All the homes still have bullets in the walls that they've left, and you can go and see and stay in bed and breakfast or go to the restaurants. But the problem is the residents don't want to change the stairs to allow people like Marilyn in. They say it'll take away from their character. Instead of having little ramps that can go over top of the stairs, which would cost $50, they refuse, or allowing them a bathroom entrance. The Historical Society had to redo part of their stuff because they were non-compliant and stopped all these people and children from not being able to see these events. Well, the town locals, which ironically I'm writing another paper from a town that I came from in Ligonier, used one of the most popular sites today, a blog site they created. Borough Vent, it was called. And Borough Vent was run by the town council, of all foolishness. And inside of this, they are the owners. They are the publishers, the same as a newspaper publisher would be for the New York Times. And they allowed people to come on and admonish the character of Miss Phillips, Dr. Phillips. At first, since it was a written piece and published, it was Liable Pro Quo. Anyone could see it, read it, copy it, see it for date. She was named in person. Others jammed on to this site without control. The editors mocking back the comments that they were making, saying they knowingly regarded them as falsehoods by understanding and interpreting them, and allowing even ones where they were calling her different names and adjectives to animals and various creatures, and saying her intentions were vile and for personal gain and harm instead of value for someone else. Well, the blog site turned into a spiral of months of heated agitation and ignorance towards not only Marilyn, to her husband who had nothing to do with this. And furthermore, her college and other people. The American Disability supporters got involved. And it came down to federal law, looking at federal laws and the way we are looking at these things as platforms today. And it's still an illegal case today, and I didn't understand how it couldn't be done, how it couldn't be stopped. So I looked at this case. They used slander, which is the actual voice. So there was libel pro se, liable pro quo, and slander, defamation of character, false light, all these things that were statute court laws are not being pressed correctly. So I started looking, how can I help her? I'll write a paper. I'll work on this. I'll find out what's going on in the world. So I looked at first as a household name. She's a known Vortex public figure, and that's one of the defenses of the council, that they have fair right to make comments of her. Fair rights are fine, as long as fair rights are honest, not negligible, not evil, not malicious intent, as we saw that list of what falsehoods could be in Malice. She has the rights for the federal law for American Disabilities Act. And we also know that there's foreign laws that protect for our foreign travelers come here. They should be able to see these rights too in the historic locations. So we have multiple implications here. The negligence, it comes from the limited gross negligence to compensation. There can be actual injury and defamation of character, and the courts can say this and say, well, it's limited, and give someone a viable payout or compensation in some way. Maybe they make them take it down or apologize or pay a fee or do whatever, that would be agreed upon. But when it comes to compliancy, it's larger. This is a town now making a person go away when their whole economic value is bringing people in as tourists to see this. Restaurants are shutting her out. Hotels won't book her. Terrible events are happening, and she's being defamed. Her knowledge is defamed. Her education is defamed. So I looked at what would change this. What is the difference? The United States, for Jacobins, was a protection from assault case. It said the unconditional and specific expression of intention, immediately to inflict injury, remove a person for protection from the First Amendment. These are things that we're talking about now as First Amendment rights that how can they take away from a single person? In prodigy cases, they strictly use this as an idea to say it's an editorial control. We're allowed to say something against someone else. You can when it doesn't become malicious and wrong. This is still a liable pro se case. It's directly printed. So I said to myself, there's got to be more. And I kept digging, and I found recently a case called Rankard versus Lewis. And in this presiding law, in which they were a similar thing happened in Canada, a professor was defaming another professor out of ignorance on his blog site. They sued, and the Canadian courts found in the wrong, in defamation of character, and sued the university for allowing it because he used the university's platform to facilitate his personal blog site. The court wrote, with the ease of which information can be published on the internet might lead some to think there are no restrictions. But writing something in a blog is no different than printing it in a newspaper or broadcasting it on a TV. It is still publishing. It is a subject to pertinent laws. Freedom of expression does not include freedom to publish information that will interfere with the judicial process or endangering people's well-being, privacy, or reputations. Libel on the internet is still libel. The ease of cut and paste does not override copyrights. Very interesting statement by that judge. And this is something I was looking for, and I framed it back out to say, here's my paper. The law needs to be changed in our world, and my suggestion and my furthering conclusions, which you'll read in the paper, says that this law needs to be revised, and she needs to go back into the courts and now post this on this preceding law and others that are coming. I noticed recently when I was buying a home that in the real estate markets, you must have a contract in hand, and until it's written down, you don't have a contract. Verbal agreements can be made, but they don't hold up in court. My real estate agent and another were going back and forth on their phones, using text. The homeowner agreed to this price that I had asked, and then tried to back out of it. And I found a court case, ironically, in Pittsburgh, Pennsylvania, that just won in a matter of a day before, to where texting is now court record because it is a transmission loop. So that opens up a new world of laws. Maybe some of you want to look into that excitement, because I actually used it the other day because I got my house for $10,000 less because of that little preceding law that happened 2 days prior. I was able to capture my real estate agent's phone, her data, the transmission from the owner's phone, and I was able to take the offer to the court and make him pay for the court legal fees and give me my money. Sometimes the law works really good. These are interesting things I want you to think about. How is the cyber world changing us? How are these old laws coming through but still there today? This is going to be an exciting semester. It's not just about law. It's about finding ways to help yourself and help others, help your organization. Maybe you become the next person in governance who says, you know what, guys? We can't use our cell phones to transmit anything. We cannot use a server outside of here. You cannot let your individual employees come in with their own iPhone and work off of it and not know what they're doing. They have to agree to governance on their phones. You might be able to set the new law. I'm looking forward to a great semester. I'm looking forward to the next 8 weeks. I'm always available on my cell phone. If you guys need me, right now I'm in and out of the loop while I'm moving here to Georgia. But email me at any time at Scott, SCOTT.Spangler, SPANGLER, at mga.edu. That's the best way to get a hold of me. It comes right to my phone. I usually respond right back because it's always in my pocket. I am a digital immigrant. Have a great day, everyone. Thanks for listening.